Good morning, everyone. I'm Nigel Barmer, Research Director at the Victoria Law Foundation, and the VLF and UCI Law would like to welcome you to the second day of our International Access to Justice online forum. I'd like to start by acknowledging the traditional custodians of the land on which we meet today and recognise their abiding connection to this land, its waterways and community. So the office of the VLF, and where I'm sitting now at home, is on the traditional lands of the Wurundjeri people of the Kulin Nation, and it's my privilege to pay respect to their elders and to all generations of Wurundjeri people who have nurtured this land for over 50,000 years and continue to do so today. I'd also like to welcome elders and community members from other nations with us today. So we're excited to be hearing from experts around the world on a range of issues related to access to justice today. Today's sessions are this session, Legal Need Empowerment and Older People. That'll be followed by a session on culturally appropriate service design and delivery, and then courts and COVID-19. Every session of the forum will have its own link. We'll be sending these out to everyone who's registered. You can also find these links in the forum program, which was sent to everyone who's registered and can also be found on our website. You can find links to all the sessions through the ticket platform Humanitix, and we'll be posting the link to the next session in the chat towards the end of this session. Some brief housekeeping. Only panelists can be seen or heard in this webinar. All attendees' videos are turned off and the audio is muted, but please do use the question and answer function to ask questions or upvote other questions. There'll be time to get to these as we go through the session. Towards the end of the session, we'll post a link to the next event in the chat function. Feel free to continue to that session, or if we're still going, stick with us here. All of these sessions will be recorded so you can catch up on them again later. So the first session for day 2 of the forum will be on legal need, empowerment and older people. In one of my main areas of work, legal needs surveys, older people are frequently overlooked. They can be excluded from sample frames, unintentionally discouraged from participating, or not properly engaged, either because methods aren't sufficiently tailored or because of inappropriate questions. The net effect is that older people's legal need narratives can be overly simplistic and their voices aren't heard. So today's session will explore some ways in which older people can be better represented, empowered and included in the dialogue. And to this end, I'm delighted to introduce Susanna Sage Jacobson, Research Associate at the University of South Australia, her colleague Eileen Webb, Professor of Law and Ageing at University of South Australia, Frances Batchelor, Acting Director of the National Ageing Research Institute, and Catherine C. Pearson, Professor at Dickinson Law, Pennsylvania State University. And the session will be facilitated by Ian Yates, AM, Chief Executive of the Council of the Ageing, COTA. So at that point, I shall hand over to Susanna and Eileen, and I hope you all enjoy the session.
Sorry for the delay. I'm just trying to share my screen. Are you able to share your screen, Eileen?
We have, yes, we did. We did before. So hold on. I'll just move back to your slide, Susanna. Hold on.
Apologies, everyone.
I won't, just bear with me a second. There we go. How's that?
Thank you very much. So hello, everyone, and thank you so much for tuning into this really interesting and important forum. Eileen and I are really grateful to be a part of it, and we are really hoping that we're able to share with you some quite brief insights into what is a topic that we're very passionate about. Eileen and I both researchers in law and ageing and have been engaged in this space for quite some time. Eileen more in the property focus, and myself in more of a regulatory area. But we are acutely aware that legal needs are increasingly at the forefront of what covers across a very broad research area of law and ageing. When we looked at this topic, we were aware that legal needs research at the moment in Australia is limited. Now, when I say that, I want to be very careful to point out that it's not that the data is not available. There are a lot of people working in this space producing amazing resources. It's more that the research focus for some time has not been on crunching that data or being able to do large scale surveys that were done early in some decade ago. And it's really important to acknowledge that we really need to update that data, particularly in an area like ageing, where we have actually had quite broad demographic shifts. So we are coming from a position here where we can't really necessarily proclaim to be speaking to legal needs as such, as a user-centric focus. But what we believe we can bring to this discussion is more an overall picture of what we see as the current barriers to access to justice that we have that have cropped up time and time again in our research, and that's what we'll be presenting on this morning. So on my first slide is perhaps the most important issue that we need to raise today, and that is the persistence, the insidious persistence of ageism. And this is a social problem, as we know. It is also very much a legal problem. One of the other things that Eileen and I are conscious that we're not going to dig into today is the huge push that's been made by advocates here in Australia for a convention on the rights of older people, and there is a huge amount of work being done around that issue, which goes to the heart of this question of ageism. But luckily, I think if the people have questions about that, I know that our facilitator Ian can probably talk to some of that, update us on some of that. But we just did want to flag that it's such an important fight to be had on a broader level. And looking at the, again, starting with the international position, but this is highly relevant to Australia. We have had a report out of the WHO and UN as recently as last year, just giving us shocking data, shocking evidence of the prevalence of ageism, and I suppose reminding us that not only has this issue not gone away, but it's possibly even getting worse. We have a situation, and I've just put a couple of things here just to, for shock value. The UN report found that 1 in 2 people generally hold ageist views, and that's often views about themselves. And ageism is, I suppose, the elephant in the room in all of this this work that we do. It comes in on the supply side and the demand side. It comes in as a social issue affecting the confidence and the help-seeking behaviour and the simple sense of self-worth of older people. But it also affects the supply side in terms of how lawyers, how courts, how systems, how legislation is framed. It really is an important issue, and it's kind of time's up, I think we want to say. The UN report was also important directly for us in that it did draw this correlation to access to justice, and it confirms to us that ageism compounds with socioeconomic inequality, it compounds with ableism, racism, sexism, homophobia, transphobia, to provide a direct burden on older people. And I suppose if you take away anything from our message today across whatever area we're working in with older people, it is that we really need to recommit to this fight. I've got this beautiful picture here for you to look at, and I just wanted to mention what they are. We've got some artworks up today from a grassroots project, centenarian portraits by teenagers. It's going on in South Australia at the moment, why it's topical for us, but these pictures remind us that these are people with faces. They also remind us that when teenagers often look at older people, they really look with an unageist view. Yes, I would like to acknowledge those, but also hope that you note that connection of all sort of social programs that are looking to dig into ageism at this point are really valuable to us. Next slide, Arlene.
Awesome.
So I have 5 minutes that we're sharing our time, Eileen and I just wanted to, before I pass over to Eileen to talk more about the specific legal issues that we need to tackle, I wanted to also talk quickly about this difference between social barriers, ageism being the big one, and also the legal system, and reiterate that point about it being a community-wide issue. We have this concept of vulnerability, and a lot of the legal researchers have picked that term up in terms of using it as a term that describes risk of harm. Now, we know older people are at a greater risk of harm in society. We use that term vulnerability, and I know it is controversial, and some claim it's going back again to the attributes of the older person if we talk about vulnerability. But at the moment, we don't have a better way to describe what the social conditions are of issues like needing care and having your capacity questioned that makes older people at greater risk of harm. The other big issue, and I know that Francis and Naria are doing lots of work on these kinds of issues, are the link between consumer-directed models that are proliferating, particularly in regulatory structures, that are providing this notion of empowering people through the illusion of choice. And I think this is also important to mention in terms of older people. The tech models and the consumer-directed models are not necessarily leading to the types of sort of user-centric outcomes that we would like to see. I don't think this would be a surprise to anyone listening. We're talking Centrelink models, aged care, the pension, all of this consumer-directed push to try and get what is perceived to be more choice into systems are providing even further barriers on a disadvantaged group. And we really need to think about shifting that, this idea of choice into more of a user-centric, what do people really want? So just to finish my talk then about what the landscape is, what the social barriers are for older people in 2022. I suppose I just wanted to reiterate that when we ask, is it really all that bad? I would say yes. That if we look at the research that we've had internationally, we have enough evidence now to know that older people are overrepresented in prevalence, and they are overrepresented in terms of poorer outcomes from our justice systems. While in Australia we've had limited research to draw on, I'm fairly confident to say that in the areas I've got down here, there is evidence of these poor outcomes. In terms of crime, I should nod to there was excellent work out of Northern Ireland over the past decade that provide us with this evidence. In terms of consumer fraud, there's a recent study from Israel. You know, these are similar, in some ways, similar communities with similar structures of regulatory frameworks. And then finally, abuse. And I think Eileen's going to pick up a bit more about elder abuse. We will all be aware of the work being done recently in investigating elder abuse. There's a prevalence study that came out last year that has confirmed, I suppose, our worst fears around older people. And you know, we have the evidence base. So we now need to move into recognising that, you know, this is a person. If we look into the eyes of this man here, are we really willing to accept that our justice system provides these kind of outcomes for him? And I think start digging into some of these ageist assumptions and narrative, and look at how that's affecting the legal system. So if I hand over to you, Eileen.
Thank you, Susanna. And just why I've disappeared is I'm being told that my internet is unstable. So if I disappear, my apologies. And good morning, everybody. And I'm coming from unceded Kaurna lands in the around the beautiful city of Adelaide. Thank you, Susanna. And I'll just take this forward I'll be looking at legal barriers and what I see as arguably ineffective legal remedies for older people in the legal system. So I'll be briefly looking at barriers which is basically, and Susanna has already spoken about some of the ageist attitudes and so on, so I won't labour too much there. But also I'm looking at barriers during the legal process if the older person actually engages. And then even if they get through this whole process and at the other end, are there adequate remedies? So I think we're all familiar that as early as the 2007 Older People and the Law Report, it was noted that the Australian legal system is, and I'll quote, not well equipped to address complex needs through low-cost solutions targeted and delivered in an appropriate way. Now, obviously, there has been considerable improvement, particularly through excellent services provided to older people by CLCs and legal age agencies.
It seems we might have lost Eileen, possibly Susanna.
Okay, sorry. I'll pick up where
Thank you.
Eileen has left off. Hopefully she'll come back in. So Eileen was talking about the previously identified barriers to accessing the system, accessing the legal system, and also she was going to move into talking about some more recent work that has picked up on the ethics of practice and how lawyers themselves have have contributed to this issue. Unfortunately, I don't have her work in front of me, but I think this was picked up yesterday. I was watching people discussing the fact that all lawyers aren't equal, and that there really is quite a lot of work to be done around looking at how lawyers are interacting with their older clients and the ethics of that practice. When we have the persistent issues of the misuse of enduring powers of attorney and the whole use of legal capacity to quite legally diminish the rights and decision-making powers of older people. And also Eileen has worked quite significantly in the area of assets for care arrangements, which is the quite prevalent area of where older people are being assisted by family members, but in return for that are providing their assets to the family pool, and under various legal agreements, lawyers have been complicit in that. Complicit perhaps being too strong a word, but from where we sit, and how that ends up planning out for the older people. Are the older people being represented properly in those arrangements? So yeah, I think we've got Eileen back again.
Yeah, I'm so sorry, everybody. The dreaded NBN. How far did we get?
So I've just looked at your slide of what I thought you were going to say, Eileen, but in a very very summarised way. I don't know if you can want to pick up any specific points.
No, I heard you speaking about assets for care. And given our time constraints, I'm so sorry, everybody. Now I'll just go to the final slide if I can, and I can finish up there. It's just Susanna, did you mention the ethics issues or just?
I did very briefly. I said I didn't, because I don't have your work in front of me, but I know that you have done work in that area, that it is a real issue that lawyers need to consider.
Okay, look, I'll just mention. I'll mention that briefly, and then I'll finish up. And look, basically, the main point I wanted to make with in relation to ethics is that while there's obviously excellent elder law practitioners, I feel it is problematic the way that some lawyers don't actually see older clients as individuals, but regard them more in a transactional way. And this can result in barriers to older people receiving the necessary scope and depth of advice in what can often be complex legal arrangements that can involve possible losses or even abuse and exploitation. So, so these, short periods of time that we often spend with clients, we really need to relook at that when we're dealing with older people, particularly in relation to complex transactions such as assets for care arrangements, which Susanna was just discussing. There's been quite a few disciplinary matters and also some quite significant serves from the bench in relation to lawyers involving matters in relation to older people. I'll just summarise some of these criticisms which have been made. Firstly, the confusion about who is the client. Are you acting for the older person? Are you, for example, acting for the adult son or daughter? The accurate assessments of capacity and awareness of some of the signs of declining capacity in relation to particular transactions. The need to consider the possibility of undue influence and any arising suspicions of abuse. And also, we won't have time today, but there's a variety of ethical issues, particularly in relation to confidentiality. So those of you who are joining in Australia, particularly Rule 9 of the Solicitor's Conduct Rules, and when can you disclose where you suspect that a person may be at risk of abuse. Now, Susanna's dealt with EPOAs and assets for care, so thank you very much for that. So basically, I will just finish off with just with a point about remedies, and then just some specific laws that we've had recently introduced in relation to older people. When Susanna was discussing assets for care, no doubt no doubt there was reference to the difficulty in getting a remedy, and this is one of the barriers that we see all the time in relation to these sorts of transactions. So very often they're not in writing. The older person isn't on the title, and if it fails, it's difficult to get the money back because they have to. The recourse is to equitable remedies in superior courts, which of course is expensive, it's stressful, and it's time consuming. And so often older people just cut their losses, if you like, and walk away. Something which my colleague Teresa Soames has been looking at just recently is bringing those sorts of matters into the tribunals, which is also a matter which was discussed in Chapter 6 of the ALRC final report in relation to elder abuse in 2017. And I'll just finish up by just briefly mentioning, Susanna referred before to the issue of elder abuse with older people, and there's often quite a bit of consternation about the lack of matters being prosecuted around the country in relation to elder abuse. And the adequacy, I think they are adequate, but the adequacy of the criminal laws around the country. The ACT has recently amended the Crimes Act, and there is now specific offences in relation to the abuse or neglect of vulnerable people, and a vulnerable person, as defined, can be a person who is over 60 with a form of vulnerability which are listed, which I won't go into here, but I'll be watching that legislation very closely and looking out hopefully for some test cases. And the final thing which I'll mention is, as you're all aware, and is we've been dealing with the Royal Commission into residential, into aged care in Australia, but a particular focus on the shortcomings in residential aged care. And from one of the main recommendation from that Royal Commission was we are going to get a new Act. Now, that Act is going to be based on human rights principles, which obviously I completely endorse. The one thing I'd like to finish up with today, though, is let's just say this is a shot across the bow, and this is no reflection on Susanna at all. This is me. It's wonderful that we're going to be saying that older people in aged care have certain rights, but I think it is going to perpetuate a cruel hoax on those people if we say they have rights, but there is no meaningful way that they can enforce those rights and obtain a remedy when those rights aren't honoured. So what I would like to encourage those people who were obviously at an embryonic stage of the creation of this legislation is to make sure it's a balance. We don't need headline rights if at the end of the day that older person can't exercise those rights and doesn't have a real remedy. So again, my apologies for cutting out. I'll blame the NBN, but thank you for the invitation. I appreciate it very much.
So I think that's my opportunity to take over. Thanks very much, Eileen and Susanna. I think you have highlighted a number of issues that are going to be reflected in my presentation, which is, if you like, a bit of a case study demonstrating some of those things, not necessarily in a legal sense, but in some of the research that we have undertaken. So I'm just going to share my screen. Hopefully all the technology will work. And I think we're good to go. So thank you very much for the opportunity to talk today. I'm going to talk about a project undertaken to examine aged care resident perspectives on quality of care and quality of life. And I won't go into detail about the, the results of the survey, but I'll be discussing some of the practical, ethical and legal challenges involved in trying to include a random representative sample of older people living in residential aged care in Australia. And full disclosure, I don't have a legal background. I'm a physiotherapist by training, but focus very much on health and aged care systems research. So I'd like to start my presentation by acknowledging the Wurundjeri Woiwurrung people on whose country I'm presenting today, and acknowledge the traditional custodians of the lands and waters across Australia. And I pay my respects to elders past, present, and to all Aboriginal and Torres Strait Islander peoples, including members of the Stolen Generation. So back in 2018, in response to serious incidents occurring in residential aged care, as Eileen mentioned, the Commonwealth Government established a Royal Commission into Aged Care Quality and Safety, and its terms of reference are here on the slide. But a key aspect was that they really wanted to examine the extent of substandard care within aged care. So as part of this, at the National Ageing Research Institute in Australia, we were contracted to undertake a nationally representative survey to examine residents' perspectives on quality of care, quality of life, and to explore concerns and complaints. And when I'm talking about residents here, I'm referring to people living in residential aged care, otherwise known in different parts of the world as nursing or care homes. So the survey was to be administered via face-to-face interviews with specially trained, experienced interviewers and conducted in facilities across Australia. The inclusion criteria were deliberately broad and the sample was to be random. We only excluded very few people. And we wanted to particularly include people with cognitive impairment if it was deemed that they had capacity to consent to the research and the ability to participate. Otherwise, obviously, we had to interview a nominated representative or proxy. The survey items are listed on the slide, and it was a fairly comprehensive survey covering quality of care, consumer choice, and interesting to pick up on some of those aspects of the illusion of choice, life satisfaction, and also a bespoke questionnaire on concerns and complaints. And that did include things to do with restraint, neglect, and abuse. So such a survey is potentially quite sensitive, and it was very important that we could ensure confidentiality of the participating facilities, as well as confidentiality of individual respondents. And it was crucially important that we achieved a random sample and that the participation wasn't influenced by the aged care provider, even if well-meaning. And this is something we've experienced quite a lot when doing research with residents. When we recruit participants from residential aged care, the staff and sometimes or often family members may, with the best of intentions, act as gatekeepers and direct researchers to participants that they see as most suitable. So the key challenges were to recruit facilities and ensure that they weren't identifiable to the Royal Commission and to the public, and recruit residents at the same time as keeping their participation completely confidential from the aged care provider and staff. So it was fairly easy to keep the recruitment sites confidential. We kept the names of facilities and exact locations confidential within the research team, and we didn't publish data separated out by states or territories in order to protect the identity of those facilities in remote areas, which could be easily identifiable according to facility and type. But the next challenge, that is keeping resident recruitment and participation confidential and at arm's length, was more challenging, and in particular because we're dealing with a population that's likely to have a percentage of potential respondents who have dementia or cognitive impairment. And this slide shows the processes that were planned for each individual site visit. We followed the usual processes. Interviewers assessed capacity to participate in the survey, but we reached a stumbling block when it came to residents who were deemed not to have capacity to consent and or participate. How could we actually contact their representative without the facility knowing or finding out? Because if an interviewer goes to a resident's room and they leave information there for a family member to look at and to encourage contact, then aged care staff will definitely know who is on the list to be interviewed. So to overcome this stumbling block, we proposed various solutions as listed in this table. For example, one possible approach would be for the randomly selected providers to inform all the residents and their families about the survey and use an opt-out approach. However, that really wasn't going to be viable in the sense that it would really limit the random nature and the representativeness of the survey. And you can have a look at a couple of different options that we considered and the reasons that those options were not chosen. In the end, we landed on a solution that we would ask each facility to supply a blanket list of contact numbers, not the names, of all their residents next of kin. And in that way, we could, if a person who had been selected to participate did not have capacity, we would be able to select their next of kin or their representative's number from that list and then go ahead and contact them. And then obviously we would destroy the list because we had no further reason to keep it for those who weren't included in that sampling frame. But it raised a number of issues in the context of both our Aged Care Act in the Commonwealth, the Privacy Act of 1988, our National Health and Medical Research Council guidelines, which talk about privacy and also ethical conduct of research. We had to also consider state and territory health acts because in Australia, some states actually run residential aged care facilities, so the state departments of health. We needed obviously to consider human research ethics requirements, and then individual providers had their own privacy policies that may or may not have prevented them from giving us the contact details of a resident's next of kin or representative. And, you know, obviously with all these different considerations and how they overlap, there was a whole lot of things we needed to consider about whether it might be okay to request this list of contact details from facilities. So just as an example, the Privacy Act, the Commonwealth Australian Privacy Principle, looking at reasonable disclosure of information that's related to the primary purpose of collection. And in this case, we felt that that was perhaps the primary purpose of collecting someone's phone number because they would expect to be contacted about matters concerning their relative. We have our National Health and Medical Research Guidelines, also in relation to the Privacy Act, which seem to support this and describing the right to privacy as not being an absolute right. And if the benefits, you know, outweigh what might be, you know, the downsides, then it might be something that should be considered. And then we have an Aged Care Act that covers the use of protected information. So, and as I mentioned, also the individual provider's own privacy principles. So how did we deal with the imperative to include everyone balanced with the obligations under various acts and requirements? So as a starting point, we obtained legal advice and representation. What happened? Obviously, the facilities were rightly worried about privacy and disclosure of information. Some organisations were happy to proceed, and it seemed our proposed method was aligned with their own privacy policies and their own legal advice. Some organisations sought guidance from aged care industry peak bodies, and some organisations were waiting on legal advice before proceeding. And I guess what happens while we were waiting for all this clarification and legal discussion, in the end, as with many other projects, COVID-19 had the final say because as we were underway, the pandemic really affected the aged care sector and many providers completely locked down and no external visitors were allowed. So in the end, we were able to obtain a final sample of around half the expected sample of 400, but it was still able to be representative of the general Australian aged care population, residential aged care population, although it did lead to a lower than expected percentage of proxy interviews in the final sample, because obviously we could interview those who had consent, capacity to consent and participate, but we're waiting on all those the legal avenues, etc., to be able to include representatives. So in summary, I guess this highlights some of those ethical, legal, organisational and practical issues of being able to hear from older people living in residential aged care. I acknowledge it's really difficult for providers, as they do have a duty of care and want to provide a safe environment and comply with statutory requirements. But at the same time, it does bring up these broader issues about protection versus autonomy for an older person. Do you have a right to participate in research? And just because your home is in a facility, how much real choice do you have? So again, these are issues to do with rights and to do with choice and how that is enacted. So if we think about issues such as access and empowerment for older people, how do we reconcile that need for protection with the right to autonomy? If I live in my own home or in a unit in a retirement village like the image on the left, and someone knocks on my door and they're interested in finding out my opinion on a number of issues, I can decide whether or not I answer the door, whether or not I choose to participate. I have the opportunity to have my voice heard. But if my home is in residential aged care, like the picture on the right, who determines whether I have the opportunity to have my voice heard? Do I have that choice, and can I exercise it? And how can we give agency to residents, older people? I mean, we can apply this question more broadly, at the same time as ensuring their safety. And again, this issue of the controversial term of vulnerability plays out here. And I think these are questions for all of us, all of society to ponder. And thank you very much for listening to my presentation. If you're interested in reading more about this survey, the report is available on the Royal Commission website. And I will stop sharing my screen. Thank you very much. And I'll now hand over to Catherine.
Very good. I'm not sure if my screen is being shared or not. It looks like it might not be. Let me try one more time.
Looks all good, Catherine.
Is it good? Okay, very good. Thank you. Well, I have to say, you know, Susanna, Eileen, and Frances, all of your work is really fascinating. And it strikes me too how important it is for us to think in the future about how to keep research initiatives like this going during something like COVID, because certainly there could be unique things that are coming out during COVID, you know, that we need to know. So now, or maybe our next thing is to have a plan in place for if something like this can cause a lockdown where people who could be vulnerable, particularly vulnerable, now become uniquely isolated. I'm at Penn State Dickinson School of Law, and in the United States, we certainly have long had a national framework for protecting older adults, both through the Older Americans Act that was adopted by Congress in 1964, specifically with the idea of expanding community social services for older adults. And then more specifically, even in the Elder Justice Act in 2010, that began to find some unique financial support under federal law that could go down to the states to expressly address abuse, neglect, and exploitation of older adults. At the same time, you can talk all you want to about a national framework, but ultimately implementation is at the local level. And that's where I think I've noticed, certainly in the United States, we really struggle. We have so many definitions, and some of the definitions are not universally shared. So for example, exploitation, what does it mean? We'll have a legal definition, but is that universally understood? So let me give you very briefly a fact pattern. In this fact pattern, and these are the two individuals right here, the wife was 92 years old, living at home, and her husband, who was a year older, transitioned into residential care because of his deepening issues. Then the wife had a mild stroke. It was a stroke that impaired her vision, but not necessarily her cognition. And her husband's former caregiver became her personal caregiver in the home. But at some point, he started wanting advances on his paychecks. And when it was discovered what was happening, she was writing 2 to 3 paychecks per week for him at a cost of over $93,000 United States dollars in less than a year. And the attempts to stop him were extraordinary and extraordinarily unsuccessful. Even after he was terminated on the job, he continued to solicit money from her directly. And he did it through the telephone, through burner phones. That's a hot topic these days. What are burner phones in the United States? The former president doesn't seem to know what they are. The United States Postal Service initiated an intercept because she was sending cash through the mail, a bundle of cash in an envelope through the mail, and they intercepted it with the help of another caregiver. United States Marshal Service works with the U.S. Postal Service. They went to the man's house and intercepted additional money as it was being delivered by the post office so that they could prove that he knew he was getting it. And local police and local attorneys were involved as well. The family chose not to use a local area agency on aging, in part because they did not want to have the woman interviewed directly. They knew that if they could communicate through other sources that would look at the objective evidence of what was going on, that might prevent her from having to testify directly. And that was a weakness, I think, in this whole system. I often give some kind of fact pattern like this because I think what I'm really doing is attempting to show how you need a coordinated set of definitions and understanding in the caregiving community and in the police services and in court services, even in the post office, so that you have any chance of addressing something like this, and it's challenging. I often use a story about a woman named Bertha Trout because she has a particularly dramatic story in that she lived to the age of 105 and was able to testify against somebody who was taking money from her and buying a uniquely unusual thing, a full-length mink coat for her 260-pound body. And the little lady, Bertha Trout, said, "I would not do that. I would not authorize that. I'm cheap, and that's not the kind of way I spend my money." But in this case, the reason I focus on this couple is because it's a story about it could happen to anyone. This was my parents. And so it's both embarrassing and difficult when it is your own parents and you realize somehow this happened without us being able to stop it, until quite a bit of money disappeared and our parents, our mother particularly, was embarrassed by what happened when she finally fully realized what was happening. I actually write a book called The Law of Financial Abuse and Exploitation. It was on the coffee table at their house. I think this gentleman thought it was a how-to book, not a how not to book or why not to book. And so that's a sad part of the tale. So in the United States, we're always talking about how, where, and when can we get sufficient assistance to people who need assistance. And so I personally ran an elder protection clinic through our law school using students. It was a great experience for me. It was a fabulous experience for the students, and it was a challenging experience in terms of financial support. We also have legal services offices that are dedicated to senior services. And one of the ones I know well and really am impressed with is the Senior Law Center in Philadelphia. And they have what used to be a 24/7 senior law helpline. Now it's really 2 hours a day, apparently, Mondays through Thursdays. And I'm sure that's a COVID phenomenon. But it really gives that ability of anybody in the state to call and get directed to somebody who can help them. And then wraparound services are being identified by the Senior Law Center to help them. One of the things that's increasingly been important in the United States is having attorneys step up to the plate and say, we are going to acknowledge that we represent the older person and we're not doing estate planning. We may be doing something that is estate planning, but we're not estate planners. We are attorneys who represent older adults. We're elder law attorneys. And we recognize our unique fiduciary duties. And I'd like to think that those people are not doing what was described by Susanna and Eileen, where, you know, attorneys are stealing from their clients. We do have that happen in the United States, but I'd like to think it's not somebody who is certified as an elder law attorney. Court systems in the United States have increasingly embraced this notion of access to justice for older adults. It's really become a true phenomenon. In Pennsylvania, we have a Office of Elder Justice in the courts that responds to specific issues as they come up. And this office was the result of an 18-month study by the Pennsylvania Supreme Court at their behest, with an elder law task force and report and recommendation that resulted in this Office of Elder Justice. I recommend that. Both of those are available online, both the office description and the elder law task force. And then finally, one of the things I think has been most important in my own work, I worked in Northern Ireland on issues such as this. And so I was very interested to hear about a new study, saddened by it, but about older adults in Northern Ireland being the subject of crimes. I work with a team that started in Northern Ireland. And one of the things that we early on recognized that often one of the most important points in the continuity of elder justice is getting there when that first sign of any loss of capacity is happening. And that really is often the medical care office. And so if doctors are willing to work with coordinated services, that can often get help to avoid abusive members getting their hands on, control over somebody's personal care and their financial care as well. And so we have an article that we wrote about that. We're working on a new project actually connected to that. And then finally, really one of the things that I think is important is for us to recognize that during COVID, unique issues have arisen about isolated people and the need to talk about whether that isolation must happen for their personal care and safety from a disease versus their social needs. I think that's really been a tough issue. And I think, states are getting more creative about this. And then most recently, just since the last time we had a meeting as the planning group for this program tonight, what's happening in Ukraine, and then also has happened in other countries around the world, where we're seeing the very homes of older adults being targeted for destruction in order to accomplish someone's goals, in terms of a war. And so I think I've just been struck, very deeply by listening to older adults who have said, I have no choice here. And, shouldn't that be perhaps an explicit war crime to target their homes? Of course, it should be a war crime that they target people. But one of the things that I think would help us is if we had something like targeting of their homes as an explicit war crime, is that that's objective evidence. It doesn't necessarily require anybody to testify and still be alive, which may be the exact problem. They may not be still alive. Let's make it something that we can, make it easier to use as a tool for all of these types of things. So I'm going to stop there. And I know we want to do some open questions and answers, and I've seen some of the questions that have been on the listserv.
Thanks, Catherine. Yes, we'll now have some Q&A and encourage our other speakers to come back on the screen. And maybe, Catherine, if you can stop sharing, that we are.
I will do that.
We don't, that was a huge amount of issues, and I just might say that we've talked about empowerment and vulnerability and issues from the local level to the international level, with the conversation early on about the attempts through the United Nations Open-Ended Working Group to establish an international convention on the rights of older persons. That's been dragging on now for a decade without getting to the action step. And yet we know from the UN Convention on the Rights of Persons with Disabilities that having such a convention actually then creates a hook and a lever that can be utilised by member states in their legal frameworks. So that's an important issue, for example, in Australia, about the other matter that a couple of speakers talked about, which is the creation of a new Aged Care Act as a result of the Royal Commission, and having an international instrument that you can then build real rights around. A common theme, I think, in many ways too, is the question of, and we actually have a question asking if Eileen Webb could talk a bit more about what law reform changes might be needed in her view that legal remedies aren't adequate. And that's a significant issue. Are the laws actually doing what they're supposed to do, and if the law provides for it, what are the actual remedies that people can use? And one very pertinent one in Australia is the whole legal framework, which is 9 times over in this federated country for powers of attorney, which, because of the lack of a rigorous framework, in many cases are actually an instrument for abuse rather than a protection for the older person. And that was pointed out by the Law Reform Commission report some years ago, still not actioned by our states and territories to get a common and strong law. But I'll come to you in a minute to see if Eileen, if you've got some other comments to make there. And then I think the other one, which is really an important part of the conversation, is the whole relationship between vulnerability and agency. And yes, people are vulnerable, but that does not mean that they're not autonomous human beings. And the questions of ethics are really important there, because I have to say, from a consumer advocacy point of view, we regularly see members, not only of the legal profession, doctors are worse. They really see the older person who may have some disabilities as a dependent of the rest of the family, rather than a person with their own agency and rights, and that have to be explored as an individual, even if then there's some balancing acts to be done. So I might throw to Eileen specifically about the question about, are there some things that you would particularly point to that need to be changed now so that we have better remedies? And then I will open up. There's another question really, which is about what we call in the consumer movement the digital divide, and to what degree that is an impediment to access to justice. Eileen.
Thank you, Ian. Look, with that question, I mean, how long have we got? Because I could probably chat about this all morning, but I promise that I won't. Look, there's so many, the law is so broad, so I can only really speak in relation to the areas where I like to think that I have some expertise, but the really reform in relation to getting matters involving older people into the tribunals, I think is extremely important. I'm fascinated. I'm very impressed with the elder court system in the United States, and some of the topics that Catherine has looked at this morning. I really believe that our state and territory tribunals could quite easily take that step. They're already experienced in areas of guardianship and administration. It wouldn't be a huge step, I wouldn't think, to move towards a stream, if you like, that focuses particularly in relation to older people. Now, the reason I'm doing this is not because I'm suggesting that older people are this vulnerable group that needs to be protected. Quite the contrary. But it comes to my point earlier on that when many quite everyday transactions are entered into and they affect older people, we need to start looking at them in a particular way. And that includes the way lawyers look at them, that the way includes courts and tribunals look at them, particularly in relation to matters involving, property and, a home to live in for the rest of your life and so on. So I'd really like to see reform in that area. Francis, and Ian, the new aged care legislation, I think that will be crucial. I was on a panel just earlier this week, and there was a mention of a Canadian commentator with some of the work that they're doing, in particularly Ontario at the moment, and they're saying in relation to law reform involving older people, this is our moment. And I really feel in relation to aged care reform in Australia at the moment, this is our moment. And that's why I'm really hoping that we get it right. So don't get carried away and captured by this idea, well, older people have rights. We have to balance that out, that they also have a means by which, a means by which to enforce those rights and obtain some form of justice, for want of a much maligned term, when things go wrong in these circumstances. So I guess they would be my big two, but I've got a very, very long list, Ian, so I won't go on, but trust me, there's a lot of work to do out there, as you would know.
Yeah, well, thanks, Eileen. And I agree with you about aged care, but of course, the vast majority of older people are not in the aged care system. And so, again, I'd refer to the state and territory legislation, which is hugely variable in Australia in its protections.
Actually, could I be a complete pain in the neck, Ian, and just quickly mention something about that, which I should have picked up on?
Yeah.
It is a concern to me just in relation to the power of attorney register and the plan to, basically get ourselves, well, not necessarily uniform, but close to uniform legislation in relation to enduring powers of attorney around the country. It was a major recommendation of the ALRC. It was one of the first things on the agenda for the national plan, which was 2019 through to 2023. It's now 2022. It would be wonderful to see that moving perhaps a little bit faster. And if they're about to announce something, that's fantastic. But I would like to see that move ahead.
Yeah, there is actually some progress, but not as fast as we would like, and a huge amount of pressure is being applied. Can I go, because it hasn't really been touched on? Can I go to? There's a couple of questions, as I said, about the digital divide, or one person uses technological literacy gaps, and to what degree these are a barrier these days. Compared to the past, any of you?
I wonder if it's even a digital divide or just simply a human power divide. I think that one of the hardest things for many older adults is the inability to find anybody on the other side of a telephone.
Yes.
Yeah, I think this is, this question really cuts to the core of why we need legal needs data and insights from older people themselves, because there is quite conflicting data about this. My understanding is that older people have really taken to telehealth. A lot of older people are very highly digitally literate, so it's very difficult to it's very difficult to generalize, but we do know that issues like socioeconomic issues and the compounding, the overwhelming illusion of choice, the overwhelming sort of regulatory frameworks, all those things compound, I think, with technologies. If you only have access to government services through the web, for example, it may not be that the older person doesn't know how to use the web. It may be that the forms are too much and the systems are too much. So I think we need more. Of course, there will always be people who are not digitally literate, and it's possible that in older people that they're more high represented, but I wouldn't necessarily like to generalize about whether older people are less digitally literate than younger people, because in my experience, it's a very mixed bag. And I also think yeah, I think there's a lot of work to be done in that area. And I also think that for those who tuned in yesterday morning, who were looking at, for example, the work from Stanford that were very focused on user-centric design models based on getting the voices of the users in and finding out the best. I mean, if you're using that kind of model with older people in co-design, I think that's got to be a positive. I think most older people would get on board with that, and there's no reason why technology should be a problem. And in fact, a bit like telehealth, they might find that really easy.
We're a bit short on time.
I'm sorry. I'm sorry. I'm like Eileen. I could go on and on.
Just to say that, look, I absolutely agree, and we deal in this space a lot. That many older, I mean, the fundamental proposition that I would say about talking about older people is you have to say, sorry, they're very different people across the board. But what I think is important is to recognise that for people of any age, if you actually don't take account that some of them are not digitally connected, you're excluding them. So if the only way you can find out about a consumer guarantee is via the website, and indeed the only way you can find out about what the side effects of your medicine might be is increasingly now on the website, or how you get financial assistance for something, then that's a problem, and that's a problem that we keep bringing up. Before we don't have any other questions online, can I just note for Australians that Susanna quite rightly, in my view, named the context at the beginning as ageism, and that is a cultural and attitudinal, and it runs right through. We do have in Australia, well, we are a leading member of it in Council on the Ageing, the Every Age Counts Coalition, and I would just encourage people to connect to that. A lot of resources and lots of ways of getting involved in tackling ageism. If you just type Every Age Counts, you'll find it. And I would also mention the organisation, an alliance of organisations called Elder Abuse Action Australia, EAAA. You'll find them, and not only can you find a lot of stuff to do with advocacy on behalf of vulnerable older Australians, but they also have an associated website that has a lot of great resources, as well as other people here have. So both of those are important resources. We are considerably over time, but if any of our panelists have a quick point that they'd like to make before we close, I'll give you the opportunity. Catherine, do you?
You know, one of the things I'd be curious about in talking with people from Australia, and please, anybody reach out to me. I'd love to know more of what's going on, because you're always often ahead of us in the United States. But are any of you looking at what are called improvident transaction legislation, where you identify that a particular transaction should be allowed to be unwound? Usually it's a transfer of the home when it's improvident. Maine has one of these, Northern Ireland has one of these, so it's kind of interesting.
I like the way you're thinking, Catherine. Yep. Okay. There's something else to add to the list.
It's an important question, and in a similar and related context in Australia, talking with the banks regularly now about unwinding scams. And yes, the question of a legal framework for that. The big banks are doing it voluntarily now, but having a legal framework would be helpful. Frances.
Yeah, I just wanted to say, I guess, whether it's access to healthcare, whether it's access to justice, we really do have to understand that older people are not a homogenous group. There isn't a one-size-fits-all solution, and we really have to address ageism. And I would also highlight the need for co-design, whether it's around digital, or technology, but really with all aspects of health and aged care, service and justice.
Okay, and very briefly, Eileen and Susanna.
I feel like I've had my say, Ian. Thank
Okay.
you. Yeah, great.
Yeah, same here, Ian. I think.
Okay, so I think, Nigel, you're coming back for a
Yes, I'm
summing
back.
up, but thanks to all the panelists.
Many thanks to Susanna, Eileen, Frances, Catherine and Ian for a great session. I invite you all to belatedly join our next session on culturally appropriate service design and delivery, which promises to be excellent. You can see the link in the chat as well as in the forum program. So many thanks again to the 4 presenters, our facilitators, and all the attendees for taking time to join the forum. And I hope to see you again in the sessions to come for the remainder of today and tomorrow. So thank you very much.